You spent months developing your product. You got the formula right, the packaging dialed in, you launched on Amazon and it sells. Really sells. And then one day you're scrolling through search results and you see it. Your product, your packaging, your look. Different brand name, but otherwise a clone. And it's underpricing you. That's not hypothetical. That is Tuesday for a lot of Amazon sellers. Here's what many of them don't know. There's a type of patent protection specifically designed for exactly this situation. It's called a design patent, and it may be the fastest, most affordable IP protection available to product-based businesses. Today, I'm going to tell you what it is, how it works, and why Amazon sellers in particular should be paying attention. I'm Julie King with King Patent Law, and this is Avoid the Legal Horrors. Now let's talk about the design patent doctrine in plain English. Most people, when they think about patents, are thinking about utility patents. A utility patent protects how something works, the function, the mechanism, the process. Those take years and cost tens of thousands of dollars. They're absolutely worth it for the right invention, but they're not the only option. A design patent protects how something looks, the ornamental appearance of a product or its packaging, the shape of a bottle, the layout of a user interface, the distinctive look of a product container. If your product has a unique visual identity, a design patent may protect it. Here's what makes design patents different from utility patents in practical terms. First, they're faster. A utility patent application can take 3 to 5 years to get through the USPTO, at best. Design patents typically get examined in about a year to 18 months, sometimes faster though, although sometimes they get assigned to an examination unit that is slower than molasses and don't even get looked at for 3 years, but I digress. Second, they're less expensive. They're not cheap, but they're significantly less than utility patent protection. Third, the scope of protection is focused. You're protecting what it looks like, not what it does. That's a real limitation. Amazon sellers dealing with copycats who are cloning the design, it's exactly the right tool. Once you have a design patent, you can mark your product with a patent number. That puts everyone on notice, including Amazon, that your look is protected. And it gives you something to wave at Amazon when you file an infringement report, which changes the conversation entirely. Even before then, once you submit the application, you can put patent pending and the application number on the product, which lets everyone know that you're serious about protecting your rights. So let me give you a sense of how this plays out. Imagine a business that sells a specialty food product, let's say hot sauce, and they've developed really distinctive packaging, a unique bottle shape, a specific label layout, a look that's become recognizable to their customers. They're on Amazon, they're doing well, and a copycat shows up. Different brand name, but the bottle shape and the label layout are close enough that consumers are confused. Some of them are buying the wrong product and leaving bad reviews on the original seller's listing because they think it's the same thing. Now, if that original seller has a design patent on the bottle shape and label design, they have a federal right they can enforce. They can send a cease and desist letter with a patent number attached. They can file with Amazon Brand Registry with documentation. They have leverage. Without it, they're filing a "this looks like mine" complaint and hoping for the best. This copycat problem on Amazon and other sites is unfortunately common, and it happens across many product categories. So what should you do with this information? First, look at your product and packaging and ask whether there's something visually distinctive about it. Not just that it looks nice, but that it has a specific, defined, ornamental appearance that competitors don't have. If yes, design patent protection is worth a conversation. Second, timing matters. You want to file before you put the product on Amazon, ideally, or as soon as possible after launch. There are deadlines involved. Specifically, the U.S. gives you a 1-year grace period from your first public disclosure or sale. But if you're thinking about international protection, that window is much tighter, if it exists at all. In many countries, the second it's disclosed to the public, you lose the ability to get a patent if you haven't filed already. So don't sleep on it. Third, understand what design patents don't do. They protect the look, not the function. If a competitor makes a product that works the same way but looks different, That's outside the design patent's scope. And like utility patents, design patents can be challenged, meaning someone can argue your design isn't truly ornamental or isn't novel. This is why you want the application done right, not just filed. Fourth, if you're an Amazon seller who's already dealing with the copycat situation, look at what tools you have right now. Do you have any IP registered? Trademark, design patent? That determines your options. If you have nothing registered, your options are limited, but they're not zero, and a consultation is a good place to figure out where you stand. If you're selling a physical product and you haven't looked at design patent protection, now is the time. The copycats are not going to stop. Amazon's enforcement process is better than it used to be, but it's a lot better when you show up with a patent number. You can book a consultation at kingpatentlaw.com. I'll tell you whether design patent protection makes sense for your specific product and what your options are. If it does make sense, we can talk about next steps. I'm Julie King. Avoid the legal horrors and keep rocking your IP. Thank you for listening. If you're ready to protect your brand and business, you can book a consultation at kingpatentlaw.com. This information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney. This episode contains attorney advertising material. From address and contact information are available at kingpatentlaw.com.